What is up, guys? It's Scott with Never Hedge back for another HCMC update, and boy, we've got a big sell-off going on right now after the judge ruled to dismiss the case against Philip Morris from HCMC, and we have the documents right here that will be linked in the description below, but we're going to go into this a little bit now, and then I'll attach the documents so you guys can go through it at your own leisure. And then we'll get to, some things after this as to why this is not the end of the court case. HCMC can respond, and they have said that they are planning to do so by August 6th, so 14 days from this past Friday, the 23rd. So that is good news. They will respond. They are not taking this decision lightly. So this is mostly just background on the case here. Right here is some legal precedent, Twombly, Ashcroft v. Iqbal and Twombly. We've covered that in the past. So this bit right here is important. Thus, a claim will survive a motion to dismiss only if the factual allegations in the complaint are enough to raise a right to relief above the speculative level, Twombly and Iqbal, while all the well-pleaded facts must be accepted as true and construed in the light most favorable to the plaintiff. The court need not accept as true the plaintiff's legal conclusions, including those couched as factual allegations. Accordingly, evaluation of a motion to dismiss requires two steps. One, eliminate any allegations in the pleading that are merely legal conclusions, and two, where there are well-pleaded factual allegations, and assume their veracity, and then determine whether they plausibly give rise to entitlement to relief. So this case was centered essentially around whether or not the IQOS involves combustion or not. HCMC argues that it does, and Philip Morris obviously argues that it does not. So this is part of the infringement. Does Healthier Choices Management plausibly allege that the IQOS device meets the combustion reaction limitation? The short answer is no, but before wading into the fray with respect to Healthier Choices Management's plea, in a few words about the applicable pleading standard in patent infringement cases, plaintiffs have traditionally needed to satisfy one of the following elements when pleading patent infringement. 1, an allegation of jurisdiction. 2, a statement that the plaintiff owns the patent. 3, a statement that the defendant has been infringing on the patent by making, selling, and using the device embodying the patent. And 4, a statement that the plaintiff has given the defendant notice of its infringement. And 5, a demand for an injunction and damages. This so-called form complaint traditionally need not satisfy the heightened pleading standards set forth by Twombly and Iqbal. Ever, a few years ago, the Supreme Court abrogated Form 18. Since then, nearly all courts have found that the Twombly and Iqbal pleading standards applies to direct patent infringement claims. So the defendants argue that Healthier Choices Management has not plausibly alleged that the IQOS device practices the combustion reaction limitation. In fact, they contend that HCMC does the opposite by attaching it to its pleadings. So Philip Morris is alleging that HCMC was proving that their device, the IQOS device, was not involving combustion because they attached to its pleading the defendant's modifying risk tobacco product application, in which the defendants contend unequivocally states that the combustion does not occur in the IQOS device. The modified risk tobacco product application was drafted by the defendants and submitted to the FDA to facilitate pre-market approval for the IQOS device. And so HCMC attached that document into their original complaint as Exhibit J. And so HCMC's decision to attach Exhibit J into its pleading has an important legal consequence. To the extent any facts in the exhibit conflict with HCMC's more general allegations, the exhibit controls courts to treat specific facts demonstrated by exhibits as overriding more generalized or conclusory statements in the complaint itself. This does not mean that the court weighs the evidence of combustion and makes factual determination as to whether combustion occurs. To do so would convert the defendant's motion into one for summary judgment. However, HCMC HCMC has pled its case in a manner such that while the court will accept its allegations as true and draw all reasonable inferences in its favor, it may do so only to the extent that Exhibit J does not contradict its pleading. In other words, the question before the court is, has HCMC stated a claim for which relief could be granted accepting the well-pleaded facts as true to the extent that they do not conflict with the attachments and making all reasonable inferences in the plaintiff's favor to the extent they are not foreclosed by the attachments. So the problem is the Exhibit J that they submitted with their original complaint directly refutes the allegations of combustion. But we go to Twitter here. Julian Saunders drafted a whole prospectus as to how the Philip Morris IQOS device does involve combustion. So let's get to that. So we can see here that it's not all doom and gloom, and the panic selling may not be warranted. It seems like they do have a legit case here. It's just that they included something in their original testimony that directly contradicted their whole case. is the issue here. Here's the bombshell. Philip Morris does not have a patent for their IQOS device in the United States, but on the 30th of April 2019, the FDA gave Philip Morris an approval to sell their IQOS device in the USA, presented that the device does not go above 350 degrees Celsius. On August 19th, 2020, Philip Morris was granted a European patent for the IQOS device, and here is the quote from the European patent regarding the temperature range of the IQOS. Preferably, the electrical energy is supplied to the heating element or in embodiments where further heating elements are included, or to one or more of the heating elements until the heating element or heating elements reached a temperature between approximately 250 to 440 degrees Celsius. And so here we do have a response from HCMC regarding the patent infringement lawsuit case against Philip Morris. This came out today. Healthier Choices Management Corp today announced that on July 23rd, 2021, the District Court for the Northern District of Georgia granted Philip Morris USA Inc. and Philip Morris Products S.A.'s motion to dismiss HCMC's patent infringement action against them. HCMC has 14 days to file a motion for leave to file a further amended complaint, which HCMC intends to do by said deadline. So we are going to have to wait and see what they have in store for us on this. And so, as always, guys, please make sure you are subscribed to the channel for more updates on HCMC as well as other stocks and tokens we like. And I thank you guys so much for watching this far, and I'll see you in the next video.